All right, good morning, good afternoon, good evening. So, if you have clicked on this video, it means you're a law student or you are doing a particular course that you maybe offer a law course. For example, accounting, business admin, I think you must be offering something like business law of contract. So, this video will teach you how to answer questions in your exam, especially when it concerns law, the law courses you are doing, if you are not doing law, and you as a law student, your core law courses. Yes. So law faculty questions come in two ways. Of course, in three ways actually, but most rampant is in two ways. There are some schools that set the third way, which of course would prepare you for Nigerian Law School. So the third way is how Nigerian Law School sets their questions. So it will also be needed if you are also going into the Nigerian Law School or if you are yet to take your exams in the Nigerian Law School. So you just wait for the third one. So I will start from the first one. The first one will have the case questions, like questions that is scenario based. They will paint a picture and they will say advise the parties. Most of the times it is advise the parties. Most of the times it is advise a particular party. Now the second one is the essay question. The essay question is you don't need any scenario. They will just tell you we are final not because we're infallible, but we're infallible because we're final. Some Justice Oputa. What is your take on the finality of the Supreme Court in adjudicating matters? You understand? Or you might see something like Lord Denning stated that God forbid a lawyer should know all laws, but a lawyer should know where to find the law. What is the benefit of legal research as concerns a lawyer in his field of endeavor? So all those ones are essay questions. So there is also a way to answer them. Then the other one is what I call the Nigerian Law School pattern of setting questions. So in Nigerian Law School, yes, it is scenario based, but not the kind of scenario based question you see in the university. In law school, they will paint a scenario, but they are not asking you to advise the parties just like you have in your universities. But after painting a scenario, they will now ask so many questions based on the scenario. So they might say comment on the validity or otherwise of this. They might say what do you comment on the propriety or otherwise of this. They might say, so these are just they paint a scenario and they set a lot of questions on it. So when they say comment on the validity and comment on the propriety, you are not supposed to use the way you answer the question in the scenario-based question for universities. So I will teach you how to do all this. So the first one is the scenario-based questions, or the ones we call the case questions. Now, in case questions, that is how we answer it. And first of all, before I even start, you should understand that in order for you to be the best, in order for you to have your A's, you must answer your question in such a way that it will not stress the marker. It will not stress the lecturer while the lecturer is marking. So that is the secret first class people will not tell you. You are not expected to come and start telling a lot of stories. Your marker, the lecturer has a lot of scripts to mark. And so when you just start, maybe you just start without making sense. And you say, okay, let me just dance around. Then when I get to the end or in the middle, I'll put the main point. If you get to the lecturer might not even read up to the middle. The lecturer might just be reading and say this person is talking off point and mark you bad because he has a lot of scripts to mark. So you should understand, have it at the back of your mind that your lecturer has a lot of scripts to mark, and if you write your answers to be straight to the point and giving him what he wants, then you are on the right track. Now, in answering case questions, that's for number one, we have the IPAC rule or the IRAC or the ISAC, depending on how you want to call it. Of course, I will tell you the difference on the P, R, and S that I used, but it all means the same thing. Now, IPAC, or me, I like to say IPAC, but people like to say IRAC. People also like to say ISAC. So I'll just say I'll put it on the screen, P/R/S, then AC. So I is issue. So when a case question is given, of course, when you are trying to write exams, they are preparing you in law to face life scenarios. And now when a particular person comes to your office, to your chambers, and talks about everything that has happened, hey, 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 and this one, he slapped me, he did this one, he did this one. What you are supposed to do as a lawyer, first of all, is to distill the issue. What is the actual issue that I'm supposed to look at? What are the issues that are supposed to that I'm supposed to be concerned with? So that is how your case questions are. Your exam questions is like a mirror of how you will be treating your life matters. So you are looking at it and you're saying, okay, this one has happened. Okay, let me use a particular scenario so that we will not be confused. Now, Emeka that is living in Abia State, Southeast Nigeria, had a fling, or will I say an affair, with Mrs. Ada. Mrs. Ada is married to Mr. Obinna. And as they were doing what they were doing, at a particular time they were doing the thing that they were doing, the friend of Mr. Obinna saw Mrs. Ada and Mr. Emeka doing what they were doing. Don't ask me what they were doing. Now, the friend of Mr. Obinna now told Obinna that, I saw your wife and Mr. Emeka, Mr. Emeka, in one hotel. They were entering inside the hotel. Now, Mr. Obinna comes to that place and sees the wife and Mr. Emeka. And because Mr. Obinna has connections in the police, Mr. Obinna now made calls, and they came and they arrested Mr. Emeka. And now they want to charge Mr. Emeka to court for adultery. They will now say, advise the parties. Now, you will now see that this is a scenario that has been painted. Now, the issue, of course, now remember, hold your ears and see this, take this one. You answer questions in law based on what you have been taught. Most of the times, if this kind of question, for example, is coming under legal method, yeah, the way you will answer it would be different from when it is coming under criminal law. Because in your legal method, the lecturer does not expect that you must have been taught, some things in criminal jurisprudence. Yeah? So if you are doing your criminal procedure or your criminal law, then you will now start looking at, okay, how was he arrested? You might put an issue, whether his arrest was with the law or by the law. And maybe they might say something about that he was in jail, in police cell for like 3 days. If you are still doing legal method and you see this kind of question, what they are trying to let you know, or what they are trying to test your knowledge on, is based on your knowledge of criminal law and civil law. I think that's in the classifications of law. Yeah? So, but when you have the same question, though, when you now go higher to like criminal procedure, you will now start looking at whether the arrest was valid. You will now start looking at whether the constitutional safeguards of the suspect was followed. You will now start looking at, okay, whether he was arraigned appropriately. Anytime, I know there are so many people that used to do Aituno that will go and be reading, they will be in year 1, they will go and be reading something in year 5. And when questions like this come out, they will now want to use their knowledge of year 5 to answer something that is in year 1. You will fail. So that is what I say, let me say. Now, in this one, you are saying issues. Whether adultery can be considered a crime in the south of Nigeria. That is the issue. Or whether anybody can be convicted for adultery, and whether anybody can be arrested for adultery, or whether adultery is a crime in Nigeria, in South Nigeria, Southeast Nigeria. Now, that is your issue. Your rule is the authority you are basing your argument on. Now, when you have distilled the issue, in law, there is nothing you are doing without authority. When I say authority, I'm talking about what particular case or law that provides for what you want to argue about. So your issue is a question: is adultery a crime? Whether adultery is a crime. Issues usually come by whether or not adultery is a crime. Now, your rule is your section of the law, or your case, or your, of course, your source. What you want to argue now. You want to argue on whether or not adultery is a crime. What is your base? What is your authority that you're arguing about? That is your rule. This is when you now start explaining those principles that you have been taught in class. Because of course, like I said, rule, arrow, IRAC, rule is arrow. Then P, if it's IPAC, you're using its principle. Then if it's ISAC, you're using, I think it's statutory provisions or source or something. So when you are now giving, because in your class, nobody comes to teach you how to, your argument. They are teaching you the principle. So all those things that you are not learning in class pertaining that particular thing, this is where you are to write them. So now in your rule, you cannot start talking about the classification of law. You cannot start talking about, okay, that in our criminal jurisprudence in Nigeria, we are divided the south and the north, where the penal code is used for the north and the criminal code is used for the south. Then you now start talking about section 36 sub 12 of the Constitution that says that nothing is a crime if that thing is not written and the punishment thereof prescribed, then it is not an offense. Then you now say in the criminal code law, there is no place that there is the case of adultery or the offense of adultery and all that. So this is where you explain all your rules. Now your argument is when you answer the question that your issue has posed with your authority or your rule. So your rule is section 36 of 12, that nothing is a crime when blah, 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 blah. And the difference between our criminal division based on the north and the south. And of course, we are talking about the south, so we will focus on the south, which is using the criminal code. Yeah? So in your argument, you now start answering the issue. I submit, or okay, sorry, this is how we do it in court. But you can now start saying that adultery is not an offense in Nigeria because based on section 36 of 12, which of course you have already cited at your rule, nothing will constitute an offense if it is not written down and the punishment thereof prescribed. The offense of adultery is not embedded in our criminal code, which is peculiar to the South. And as such, therefore, it is impossible that somebody can be arrested and criminal proceeding be instituted against the person as regards adultery. At most, it can come under the civil law, which particularly under the matrimonial causes. Of course, the matrimonial causes has given the one of the ground, or no, one of the facts of the ground of dissolving a marriage to be adultery. So, at most, what Mr. Obinna can do is to divorce his wife on the ground of adultery. Yeah? So your conclusion is when you now start advising all the parties. You advise Mr. Obinna, you advise Mr. Emeka. Mr. Emeka, he did not commit any crime, but, he should stop doing rubbish. You understand? So you advise everybody in your conclusion and you end it. Case questions are usually the sweetest to answer. Because as long as you know your principle, if you knowing your principle means you pay attention in class. Because all the things they teach you in class are principles. So it is now your own brain that you use to distill the issues. If you distill the issues, you will now apply the principle, then you now answer the question that your issue has posed based on the principle that you've learned. Now, when you are doing that, you are arguing. That is your argument. Now, after the argument, you will now, based on the argument you have proffered, advise the parties or answer the question that was given. Maybe they might just say advise just one party. Then you now do that in your conclusion. That is how to answer case question using the IPAC rule. Now, essay questions is the way we answer essay question. You have your introduction, body, and conclusion. So your introduction is kind of like a table of content. I said it's kind of a table of content, or it's a paragraph that will tell the lecturer what you want to do in the body. In the course of this answer, I will be distilling the types of jurisdiction. I will explain the types of jurisdiction. I will talk about the original and the this thing. So you are trying to, in your introduction, trying to tell so that when the lecturer reads your introduction, the lecturer already knows that okay, you're actually on the right track. Okay, these are the things that I'm expecting to read in this person's question, in this person's answer. And please do well to be headlining your what do you call it? Your essay, this thing. Headline them. So when you say you want to explain the types of jurisdiction, so you start by okay, after listing them. So the types of jurisdiction that I'll be explaining are original jurisdiction, appellate jurisdiction, substantive jurisdiction, procedural jurisdiction, all that. Now, when you finish listing them, and you want to, and now I will explain them briefly. Give one line and write original jurisdiction. Underline it or write it in capital letter if you don't need to underline it. Pom pom. Pom pom is colon. Then you start. Original jurisdiction, blah 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 blah, is the power of the court to hear the matter for the first time, blah 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 blah. Then you put some kind of cases. In section 230, is this 233? The Supreme Court, has the original jurisdiction to hear matters that comes up between the federation and the state, between this. Then additional jurisdiction, additional Supreme Court jurisdiction, blah 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 blah. 2002 gives the Supreme Court also powers to hear all those things. Original jurisdiction, you have explained it. Full stop. You go next line. Appellate jurisdiction. Now, what will this do? This will tell the lecturer that you know what you are doing. Your work is organized. And when your work is organized, the lecturer is happy. Because the lecturer wants to just say, okay, you know original jurisdiction. Maybe the lecturer wants to see what you explained in your concurrent jurisdiction. He doesn't need to come and start stressing himself, stressing his eyes, looking for where you explained it. He already knows that, okay, when you go there, you now see the heading, concurrent jurisdiction. He goes there directly. So make your heading bold so that everything that you are writing is organized, so that the lecturer will know where he is going to whenever he wants to maybe revisit your work or look at something that you did. Because if you just write it prose like that, it will stress him. And remember I said in the beginning that you must do what will not stress your lecturer, especially when you are writing the exams. Make it easy for him to read. Write to your lecturer as if he's a year one student. Don't assume your lecturer knows what you are writing. Of course, my lecturer will understand. No, write it. Don't assume anything. And make your work very neat. So after that, after all those things, you can now come to your conclusion. Your conclusion is when you now summarize, you do a summary of everything that you have done. So essay question is nice. So you remember that your introduction, you talk about what you will do based on what the question says. In your body, you try as much as possible to itemize, and whenever you want to explain something, you have to write it, bold in it, and put a colon so that they will know that okay, this is what you're explaining now. Now that is for essay question. Now, for the one I call the Nigerian Law School kind of question, what we use most of the times when they say comment on the validity of this, and most of the times it is used when you are talking about procedural law. So they will say that somebody wanted to institute a matter, a criminal matter in the magistrate court, and the person filed information. Then they now say comment on the validity of the process used in instituting the criminal matter in the court, in the magistrate court. Now, of course, we all know that, okay, not we all, I know you as a neophyte, as a year one law student, you don't know what I'm about to say, but we know that information is used in the high court, while charge is used in the magistrate court. Of course, there are some exceptions. We have the first information report and all that, and we also have where charges are used in the Federal High Court section 33 of the Federal High Court Act. But we are not going into all those things. Now, let us say generally, when you come with information to the magistrate court, we know that it is not possible. You cannot do that. So when they say comment on the propriety or otherwise of the process used in instituting the criminal matter in the magistrate court, It is simple. We use the press rule. What is the press rule? PRES. Press rule. You have the point of view, the reason for your point of view, your evidence, and your summary. So we'll use this as an example. So point of view, it is improper or it is not proper. You must write it. Our lecturers in law school that time will be telling us, you must write it is not proper or it is not valid. It has a mark on its own. It is not proper. Your reason. Because you in magistrate courts, the appropriate, what do you call it, mode of instituting a criminal matter is charges. Information can go to the High Court, which is the appropriate one for the High Court. That's your reason. Your evidence is your authority. Of course, you have come to authority again. Authority, you cannot do without authority in law. Evidence now, you cannot say section this or that this rule this, or in the case of this. Your summary is kind of like repeating everything. So saying the magistrate court cannot, the jurisdiction of the magistrate court cannot be invoked by filing an information, as it is not proper to file information in the magistrate court. The proper court information is supposed to be filed is the High Court. And so the process is grossly improper. You cannot put another authority, or your authority that you put in in the middle is okay. Because in law school, of course, authority, according to what they told us, authority is half marks. So that is how to answer questions in exam. So please, you would ace your next paper. Please ace your next paper, and be sure to listen in class when they are talking about principles, because like I said, you cannot do anything in law without authority. So when they are talking about the principle, and authority is not just only cases and all that. Learn the principles. When you learn the principle, you learn the cases or the laws or the authorities that the principle is based on. So when they are teaching in class, listen very well, make your notes. Read it very well so that it will be part of you. Argue with it, talk to your friends with it. So that when you are in exam hall, in your rules or in your principle, you will not be. In fact, if you know the principle, yeah, and you see a case question that talks about that principle that you know, it will be easy. You even be smiling as you are reading it. So I hope you have gotten this. So the first one is case question, where we use the hierarchy, the issues, rules, principles, or statutes, arguments, and conclusion. The essay questions is we use introduction, body, and conclusion. While the one we call Nigerian Law School question. Now, if your university sets question just like the Nigerian Law School questions, which I usually advise universities to actually set this question so that the students would be prepared for Nigerian Law School, because of course it was in Nigerian Law School that I learned, because it was new in Nigerian Law School that I learned that this is how we have to answer these kinds of questions. So I encourage universities to set these kinds of questions for their students. So if your school is that kind of school that sets these kinds of questions for you, you use the press rule: point of view, reason, evidence, and summary. Now, this is the shortest. In law school, of course, they will tell you that you don't need to write too much. Just short. Most of our lecturers will say, no, your question, your answer should be like a lady's short skirt. Short enough, okay, long enough to cover the vital parts, and short enough to be attractive. So that's like, but that is for law school, or maybe if your school sets those kinds of questions. But for IPAC, you just write until you are done with the principle that is surrounding that particular case question. Then for the essay question, you have to write everything you know about that. So thank you very much. I hope you have a good one. Peace.